Hello and welcome to another edition of HIPAA in the News. This is going to be the June 2022 edition. Let's get started. Okay, so we're going to dive right into the first article here that's talking about how HHS issues guidance on HIPAA and audio-only telehealth. Now, this particular situation is sort of an outcropping of the pandemic and essentially a lot of use of telehealth, but it was going to happen inevitably anyway. If you actually look at this notification and some of the verbiage in the notification, what you'll see is they're specifically talking about, if you kind of get into the weeds, how certain tools like Apple FaceTime, Facebook Messenger, video chat, Google Hangouts, Zoom, or Skype, you can actually use those without having to get a BAA and provide telehealth under those tools, as long as the data that's transmitted is transient and isn't stored. And then it basically says that public tools like Facebook Live, Twitch, or TikTok that would be publicly facing and recorded potentially, those of course are not covered for healthcare providers. And then basically, if you're going to use a tool like Skype, you can see the list here: UpDocs, VSE, Zoom, etc. And kind of go down the list. GoToMeeting. Then you will need to enter into a BAA based on some of the criteria that they list here. And then they go on to say that it's not an endorsement, et cetera, et cetera. So kind of to summarize, a lot of folks are really interested in this, of course. Does being HIPAA compliant require that I get a BAA for these telehealth provider applications? And can I use some of these different applications for, administering telehealth? And the answer, according to the regulation, is pretty plain to see. And just kind of as another summary, another form of summary, essentially this article from a legal group that is watching this and summarizing it, they basically say that the answer depends in part on whether your vendor creates, receives, or maintains the patient's information, as opposed to simply acting as a conduit for the PHI. So long as the vendor has only transient access to the information transmitted, then no BAA is needed. That's their interpretation of that notification. On the other hand, if PHI is being transmitted via a smartphone app and stored in a cloud format, a BAA may be necessary, emphasis on the word may. Similarly, if a patient's information is translated by an app from one language to another, likely a BAA would be required. So that is the summary, folks. If you are trying to do telehealth, basically the OCR is clarified in this notification that you're actually able to do that just fine using different tools that a lot of folks were just not sure about. In particular, these tools here that you can see that I have highlighted. So definitely an interesting development with this piece of news. Okay, let's dive into the next topic. Okay, so this next article is talking about how HIPAA isn't a medical privacy law. And this is a pretty interesting document. So this particular article kind of goes in, let me zoom it in just right here, and basically says that HIPAA doesn't actually protect medical data. People think that it's sensitive data and therefore it's protected, but that is just not true. Now, we're going to go through a few examples and kind of debunk or kind of go through some thoughts that people tend to have about what HIPAA does and doesn't cover, and just kind of get this author's view on that. But the law was enacted in '96, and it was mostly concerned at the time with issues like helping people maintain health insurance when they change jobs. And it does lay out privacy rules, of course, and security rules now too, that help healthcare providers and insurance companies to follow those rules whenever they handle personally identifiable medical data. But that's kind of where the rub is, because essentially we should have strong protections for all sensitive health data, but the law just hasn't caught up. And so we're going to kind of go through some of those examples here. So one example that's pretty prominent is just browsing the web for health info. HIPAA doesn't protect you. And you can kind of go into the weeds and kind of look at some of these examples, but retargeting and remarketing is a great example of that. If you're browsing around the internet, there's some really personal information that you might be browsing for, and marketers can still target you with that potentially, one would think, HIPAA data. But in fact, it's not really covered by the law. The law is basically silent in that area. Wearing a smartwatch, no, HIPAA doesn't protect you. And it's basically saying here, to be clear, that doesn't mean that any particular company is using its customers' heart rate data for advertising or product development. It just means the law doesn't prevent that from happening. So mostly what you're seeing is that there are kind of good actors that haven't really exploited it where the law is silent. Hopefully that continues to be the case, of course, but the law doesn't actually speak to that specifically. Shopping in a drugstore, it's complicated. And so it kind of depends on whether it's an over the counter medication or not. If it isn't and it is prescribed, then HIPAA very tightly governs how that's supposed to work with your HIPAA data. But if it's over the counter, there really aren't specific rules that kind of go into that protection of your HIPAA data. Just moving on, security researchers have found that many tech companies refer to the data as anonymized, and that it's pretty easy to tie that back to individuals. However, experts say it would be much harder to do that with data that actually follows HIPAA's rules. And if you read the security rules where it talks about de-identified data, they say that it can be one of two things. Basically, one is you literally have a statistician, essentially, data analyst who is a professional and they're certified, go in and de-identify the data for you and provide essentially a certification that it meets those standards. The other alternative would be that you de-identify it yourself, but it has to meet the standard that it literally could not be rejoined to the original identifiable person with that HIPAA data. So basically, a lot of folks are kind of saying they're de-identifying the data, but they're not necessarily actually doing that effectively. If you are fielding questions about vaccination status, HIPAA does not protect you. Using a period tracker or other app, HIPAA doesn't protect you usually. And this one kind of goes into more detail, but essentially the problem is that depending on the area of the law that the app is protecting you for, that should be covered under HIPAA theoretically, most of those scenarios, it's not spoken to in the law. So unfortunately, it's not necessarily clear. And so therefore, a lot of times it's the terms that you agree to in the app that govern the privacy as opposed to HIPAA kind of taking over. Okay, talking to a doctor, yes, HIPAA protects you there. And that one's pretty cut and dry. There are some interesting nuances, though, with new technology like telehealth and telemedicine and using third-party providers that may not have to comply, like FaceTime and WhatsApp, which we just talked about earlier, as long as the data is not stored persistently. But how do you know for sure that it isn't stored persistently on their network? Talking to your health insurance company, yes, HIPAA protects you. Seeking treatment for a miscarriage, HIPAA may not protect you. So basically, HIPAA would be of no help if, unfortunately, if you're looking at some of the numerous exceptions that permit mandatory healthcare provider reporting. So if someone has to mandatorily report, that kind of bypasses that, the HIPAA side of things. So anyway, pretty interesting stuff here, especially with some of the, recent developments that have occurred. Bringing your phone to a medical clinic, no, HIPAA doesn't protect you. So you can literally have some of this data that you're, kind of is getting collected on your location, and that information is not technically covered according to this interpretation in this article. Doctors getting subpoenas or court orders, no, HIPAA doesn't protect you. So pretty interesting stuff. Okay, let's take a look at the next article now. Okay, so this next article says, myth or fact, physicians can't respond to online patient reviews. Now, for those of you who watch this channel, you've seen in the past, we've literally gone into examples that the OCR has highlighted on the HHS website about physicians who responded to online reviews. But here, what you can see is they're saying physicians often believe that Health Insurance Portability and Accountability Act, HIPAA, and other privacy laws prohibit them from responding to a review a patient or their caregiver posts online. The problem isn't responding. The problem is you still have to maintain privacy. So that's kind of where the nuance is to this. So they say, to the AMA's knowledge, there are no federal laws or regulations that expressly prohibit physicians or their practices from responding to online patient reviews. They're free to respond and contribute, but they must maintain the privacy of the patient's protected health information, or PHI, even if the patient has already revealed personal information. While a patient is free to share any information about their experience in an online forum, physicians are prohibited from disclosing any patient specific information. Okay, so basically, what they recommend that you do if you are responding or you're advising someone on how to respond with general policies. Think about responding offline potentially. Remember that your reputation is not destroyed by one bad review. And most importantly, make sure the practice is providing HIPAA training to the appropriate staff, and do develop policies and procedures related to what is appropriate to disclose or not. You want to especially not disclose things on social media, of course. So you really want to be overly careful if you're going to kind of mark and make sure that you are training your team. Don't respond immediately. This is just generally applicable with reviews. Acknowledge the person. Do not acknowledge that the person is a patient in your office or disclose any other information. And of course, they're suggesting that you don't ignore it or shy away from reviews. But the main takeaway here is, which is really interesting, there really is a fine line here. And even the AMA is kind of weighing in on this, because a lot of medical professionals or covered entities deal with this quite often. So it's a very real issue for a lot of folks. And of course, there's a nuance to it, unfortunately. But the bottom line is you just want to make sure that you're maintaining their privacy, even when it's online. Okay, so this next article is somewhat in line with what we've been talking about here, where hospital websites are sending medical information to Facebook. And they're doing this using the Meta Pixel. If you're not familiar with that, it can be used to retarget website visitors with advertising and for other purposes. But many hospital websites have this tool in place, and whenever people schedule appointments, according to an investigation by The Markup, their use of this tool may be violating medical privacy law for HIPAA. And the assertion here is that the patient's IP address is going to be tied to a visit, for example, when they sent a doctor's name and the condition, for example, Alzheimer's, for which the appointment was scheduled. So somebody's on a website, this Metapixel, it's a tracking code, is on that website where they're booking an appointment for Alzheimer's. And then this retargeting campaign, if you're not familiar with that, it basically takes somebody's visits on different website properties and what that is. And then whenever they're on another property that this Metapixel data is used for, then they get retargeted with ads based on their previous interest in that other website they were on. It's called retargeting. So you're targeting them on other properties all over the internet. Well, this could be a HIPAA violation, they're asserting, because it includes the IP address. It's not de-identified like we talked about earlier. Under HIPAA, hospitals aren't allowed to share identifiable health information with third parties without patients' consent. They can use and share anonymized data, and often do, but information linked to an IP address can classify data as identifiable health information, which has additional protections. That's what they're asserting here. This is pretty interesting in general, because basically the summary here is that, as we talked about earlier, this is very much a gray area for HIPAA, and the law hasn't directly addressed this. And you're seeing notifications like the one we went over earlier about telehealth and how it's now been expanded. Kind of the liberalization of some of those kind of guidances has been expanded beyond COVID. And it's most likely that we'll see more weigh in from Lisa Pino and some of the other folks at the OCR over time, so they can kind of clarify for folks until the legislation catches up to this. Okay, let's take a look at the next article. Okay, so this article is just essentially kind of a reminder of how to prevent HIPAA violations. And it's basically saying, what is HIPAA and what are the most common violations? We wanted to kind of highlight this just so you can see a friendly reminder of what some of these big kind of areas of failure are, according to this article. Unauthorized access to PHI, lack of security controls to protect PHI, improper disposal of PHI, not being able to provide patients with access to their PHI. And this is one that tends to be confusing to folks because they don't realize that's part of the privacy rule. Failure to follow the minimum necessary standard when accessing or disclosing PHI. So these are kind of some of the biggest pitfalls that folks have. You can take a look at this article and kind of go into detail. But really, just to kind of summarize it, one of the big things that they talk about here is not really following basic policies, and then essentially not really having training for the staff and putting a privacy officer in place. If you can get a privacy officer, a role doesn't have to be the only thing that person does, depending on the size of your organization. It could be multiple people that are serving in this role. But essentially, a role for a privacy officer who's responsible for ensuring all of your HIPAA regulations are being followed. Of course, most people listening to this are already familiar with that and already doing that. But maybe the question to ask is, what kind of training and resources are you putting in place? And are you comfortable that all of those areas that I went over earlier, that you've really kind of gotten into the weeds on those? Employees should receive training on HIPAA, and policies and procedures should be reviewed regularly. And it really does depend. It's on kind of a spectrum depending on the size and scope of your organization and the risk, the perceived risk from a security perspective of your HIPAA data. If you have any questions about HIPAA or you witness a potential violation, you should contact the privacy officer. And then by taking these steps, you can help prevent PHI from being disclosed improperly. A last thing we wanted to highlight is there is also a new basically release from the government that's talking about how to strengthen cybersecurity posture in the health sector. And this is really, really interesting. So this is coming basically from the security side of things. And if you take a look at this, there's a lot of great information in this. A lot of folks tend towards seeing the government issued documents as being pretty simple and maybe not covering everything, but this is actually really good stuff. Pretty simple overall to start with, but it goes into a lot of detail that can be really, really helpful. They also have a lot of great links that you can dig into. And if you at least go through these steps and follow some of these basic steps that they offer, you're going to tend toward positioning yourself very, very well. And you ought to be able to sleep generally pretty well at night. Of course, we always want to be, a step ahead of some of the issues that are out there. But keep in mind, I mean, the government is seeing these issues occurring left and right, and they're literally issuing this so that you can be protected and follow the rules. I highly recommend taking a good review. If you're in this area on the security side, it's an excellent resource to take a look at. Okay, everyone, thank you for watching this edition of HIPAA in the News. If you like this, please hit the subscribe, and we will be sure to notify you of more of these videos. Of course, if you would smash the like button, we certainly appreciate you helping us get the word out about this. And until next time, bye for now.